Welcome to this week's installment of Rochelle's Daily Wire Video Edition. This week we're going to do something different. Rather than forcing you to listen to me for a few minutes, instead we're going to interview one of the leading figures in the bankruptcy community. So sit back, relax, and let's learn something about bankruptcy law. Good day, I am Bill Rochelle, ABI's editor-at-large, and we are coming to you from the Winter Leadership Conference of the ABI in Scottsdale, Arizona. For the next few minutes, we're going to be talking to Jeff Pomerantz, a partner in the Los Angeles office of Pachulski, Stang, etc., etc. For those of you who don't know, of course, Pachulski Stang is one of the country's premier firms in the representation of creditors committees in mammoth reorganizations. Jeff began his career rather auspiciously, having been a 5.8 at NYU undergrad, believing he needed another 3 years at the same school. He stayed at NYU for his law degree, where he was, I want to say, order of the coif, because unlike many of our age, you still have hair. So
maybe gray, but you can still have it.
That's right. Now, Jeff, you're a born and bred New Yorker. How the Sam Hill did you end up in Los Angeles?
Well, I was a summer associate at Jones Day. Never thought I would actually accept a summer associate position in Los Angeles, but I was recruited by a New York transplant. And then since my wife was graduating undergrad when I was graduating law school, we decided to take a shot and move out. It was one of the best decisions I made in my career. And 3 years after Jones Day, I left to go to Pachulski and have been at Pachulski ever since and haven't looked back.
Wow, that's a typical story. Seduced by good weather, huh?
Yes, that didn't hurt.
No November snowstorms like they had in New York.
Just mudslides, earthquakes, and fires.
Oh, goodness gracious. Well, listen, Jeff, from your vantage point as a lawyer representing creditors committees, we have observed recently that in a good number of cases, debtors will try to run in and out of bankruptcy court with a reorganization plan or a sale almost overnight and marginalize creditors committees in the process. And one of the things I know you've had some recent experience with is the use of, let's call it an independent directors committee, either before or during bankruptcy, to marginalize a creditors committee. How does that happen?
Yeah, so let me first start by saying that the use of independent directors is nothing new. It's part of corporate law. Independent directors are often on boards. I think they're required to be on public company boards, and oftentimes they are used to look at transactions that are involve interested directors and to determine and pass on them. The problem, though, is how they're being used in the Chapter 11 context, which I think is seriously undermining the ability of a creditors committee to do its job.
Well, how does that happen?
So basically what happens, and it's happened a lot in retail cases, although it's by no means limited to retail cases, is there are transactions usually involving an equity sponsor that occur pre-bankruptcy, and that those transactions potentially give rise to large claims, potentially fraudulent conveyance claims, breach of fiduciary duty claims, and as part of a recapitalization, either with the sponsor's commitment of new funds or just a conversion of debt from other people in the capital stack, those claims are proposed to be washed under the rug. Now, historically, a principal role of a creditors committee would be to come into the cases and do the investigation, and to the extent that there were claims that they found were valid, negotiate those claims.
So how can you use an independent director to try to do an end run on the typical duty of the committee?
So the problem is, and part of it I think is caused by the speed at which these cases are proceeding through bankruptcy. Again, going back to retail cases, there's a limited time that the ABL lender usually gives the company to try to reorganize. And if they can't, they're going to have a full-scale liquidation. So there's a limited period of time. So what debtors have been doing in the last few years is they've been appointing an independent director. The problem being that the independent director is typically appointed by a board that has majority control by the sponsors. And the charge for those independent directors are to investigate the claims by the people they were brought.
If I can interject, strikes me that in that situation, the independent director is independent in name only.
Well, look, and I don't want to cast any aspersions on independent directors, because the people that are coming in independent directors in these cases are people with impeccable reputations, respected people in the communities, respected restructuring
Yeah, but if they bite the
advisors.
hand that feeds them, are they ever going to be appointed to another board anywhere, especially of a troubled company?
I think that is the problem, and that is basically the appearance of conflict that comes into these cases. I mean, it's similar to a company that's accused of fraud right before bankruptcy to avoid a trustee when it's filed saying, I'm going to bring in the CRO and they're going to. So I think it's a problem endemic in the situation. And when that independent director with its professionals comes in and basically takes some position on the claims, invariably it's to say the claims are not really worth all that much, they should be released, it's necessary as part of a reorganization. I think that's a problem.
Well, so then in other words, you're coming into bankruptcy, you already have a pronouncement from an independent director's committee, committee maybe, not
Could
the
be
right
committee, but oftentimes it's
whatever,
one independent director.
who was probably also represented by counsel and perhaps also an independent financial advisor, and they say, well, there's nothing here to sue. So I guess the bankruptcy court has got that report on the one hand.
Maybe yes, maybe no. In the case, more recent case we're involved in with Payless, which this played out, the company filed. The independent director's report hadn't been concluded. The independent director hadn't hired a financial firm to question the solvency analysis that had been provided by the company's expert that supported a couple of dividend recaps. And at the time, when it was said that the investigation was ongoing and would be completed by confirmation, the committee was left to wait and see what that independent director's report ultimately concluded and determine if it accepted it, or take an aggressive posture. And what we did in that case is we immediately hired our own expert. We sought to have them retained. There was some initial opposition by the independent director in the company, saying that we were sort of duplicating the efforts. I think they thought better of taking on that fight before the court, and they allowed the committee to hire its expert. We produced an expert report that, not surprisingly, showed that in our view the company was insolvent when the dividend recaps were made, a position that the lenders and the sponsors vehemently opposed. And by no means was it a slam dunk case, but it sort of played out in the bankruptcy case like that.
So you're putting the bankruptcy judge in a position where you've got wildly contrasting views about whether there are claims to be made, but the bankruptcy judge is also being told that if we don't confirm this puppy overnight, we got a liquidation.
So, but
20,000 people are going to lose their jobs. What is a bankruptcy judge supposed to do in those circumstances?
So look, I get the case where the sponsors who are the targets of the claims are contributing new money, and if the process, the marketing process, the capital raise process has been thorough, which of course can be questioned, then you may have that choice. Do you take their money and do you do reorganization, or do you not? In the Payless case, it wasn't that false choice, at least in our view, because equity sponsors were not putting in any money. They weren't necessary to do the plan. Our view was those claims should be put in a liquidating trust, prosecuted for the benefit of creditors after. The problem was the debtor, who was still the debtor and controlled the plan and had exclusivity, the other stakeholders didn't want to take on the debtor, support the committee in its view, because they didn't know if that would delay confirmation of the plan. And that's really how it turned around. In our view, claims that are existing against parties that are not contributing money to a reorganization plan, whether it's third party, whether it's releases, that has been obviously a big issue in a lot of cases over the last few years. Those claims should be put in a liquidating trust.
Yeah, right. Well, I got to tell you, all of this makes me think, and you and I are old enough to remember the old-fashioned Chapter 10, Chapter X, where you automatically had a trustee. And then, of course, we dumped the notion of trustees in major reorganizations because it was demonstrably not working at the time. But it makes you wonder, Jeff, whether maybe the way cases are being prosecuted these days, that has to be re-examined. Maybe there needs to be some other truly independent person brought in by the court.
Well, look, I do think the paradigm of a debtor as an independent party that's able to stand up to its lenders on behalf of its fiduciary duty to the estate in general, I don't think that paradigm is necessarily apropos in cases these days.
Yeah.
I think because of the way companies have been financed, because of the way companies have been over-levered, companies are entering bankruptcy with very little ability to do anything. And oftentimes, they are instrumentalities of the lenders. Having said that, I'm not sure the requirement to bring a trustee in would not ultimately result in a lot of these people in the capital structure who are otherwise willing to support a company if it could be recapitalized quickly through a Chapter 11. They may not support it. You may end up in having more liquidations. So, while it could deal with some of the independence issues, I'm not sure at the end of the day if it would be a positive or a negative. I just think courts have to be a little more of a gatekeeper and not necessarily give in to what is invariably the stance of the lenders, that if it doesn't happen quickly, we're going to liquidate.
And well, you're making a good point, which is that the system needs to heal itself before something bad happens.
I think that's right.
Before there's a scandal somewhere.
And it's also the public perception, because in the wake of all these retail filings, which a lot of the retail filings have been result from private equity sponsor-backed companies that did a tremendous amount of financings and LBOs in the 2012, 2013, 2014 period. It's really giving a bad name. People out there don't have, the bankruptcy system doesn't have the credibility and doesn't have the integrity that it has, and I think that hurts us all.
Yeah, well, you have a point, because if there is a scandal sometime, Congress is going to fix it, and we may not like the fix, because Congress doesn't have the expertise in bankruptcy that folks like you have, and so goodness knows what we may end up with. Jeff, this has been a really marvelously interesting conversation about what's going on in the big cases these days. We thank you very much for your time, and I'm going to go into the big room right now and watch you deliver a panel on much the same topic. So thank you, and I hope to see you again on one of these ABI programs.
Great. Thanks for having me.